Welcome back to The Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and today we're discussing the recent decision from the Fourth Circuit that found that America's rifle is not protected by the Second Amendment.
Kinetic Development Group doesn't just make parts for the tactical or military guy. They make parts for everyone, whether you're a hunter, a competition shooter, or a standard supporter of the Second, they have something for you. Kinetic Development Group. When you get it, it clicks. To learn more, go to kineticdg.com.
Recently, the Fourth Circuit issued a very unwelcome decision en banc in Colby v. Hogan, which proclaimed that assault weapons and large capacity magazines are not protected by the Second Amendment, a determination that has the gun community up in arms.
Boo! Boo! Boo!
A few points of order before we talk about the decision itself. For those who don't know, en banc is when the court sits as a whole to hear a case. In this instance, it was heard before 14 judges rather than the typical 3-judge panel. In order for a court to hear a case en banc, it can either do so on its own, or a party can petition the court for a rehearing. The other point I want to make is that the Fourth Circuit covers Maryland, West Virginia, Virginia, North Carolina, and South Carolina. So if you live in a state such as Maine or Texas or Wisconsin, this decision does not directly affect you. Colby had challenged Maryland's Firearm Safety Act of 2013, or the FSA, which banned AR-15s and other military-style rifles and shotguns, as well as detachable large-capacity magazines, by contesting the constitutionality of the law under the Second Amendment, as well as bringing a 14th Amendment due process and equal protection claim. For the purpose of our discussion, though, we're only going to cover the Second Amendment aspect. At the district court, the judge ruled that the FSA was constitutional. While analyzing the Second Amendment claims, the court expressed doubt that assault weapons and large-capacity magazines were protected by the Second Amendment. In its decision, the court employed an intermediate scrutiny analysis. When a court employs an intermediate scrutiny analysis, it looks to see whether the challenged law furthers an important government interest by means that are substantially related to that interest. In this instance, the district court found that Maryland's law furthered the important interest of providing for public safety and preventing crime, and did so in a manner that substantially furthered that interest. Boo! Intermediate scrutiny does not require that the manner in which the interest is furthered be the least burdensome. The court looked at evidence presented by both parties as to the capabilities of certain firearms, etc., to arrive at this conclusion. The decision is in the description if you want to read it. Colby appealed to the Fourth Circuit, and a 3-judge panel reversed the district court's decision. The panel found that the Second Amendment protected the rifles and magazines that were banned by the FSA. Of equal importance, the 3-judge panel also found that the appropriate level of scrutiny to analyze the constitutionality of the FSA was strict scrutiny. Again, quick lesson for those who don't know. Under strict scrutiny analysis, the law must further a compelling government interest and must be narrowly tailored to achieve that interest. Simply put, the law must be written in the least restrictive means possible in order to further that compelling government interest. As you may have guessed, the 3-judge panel remanded it back to the district court to decide the case in accordance with the panel's decision. That is, until a hearing en banc was granted. And before all of you give up hope in the federal judiciary, I think you'll appreciate this brief excerpt from that 3-judge panel decision. The meaning of the Constitution does not depend on the popular vote of the circuits, and it is neither improper nor imprudent for us to disagree with other circuits addressing this issue. We are not a rubber stamp. We require strict scrutiny here, not because it aligns with our personal policy preferences, but because we believe it is compelled by the law. Unfortunately, what would have been a welcome difference in the opinion between the circuit courts was overruled when the case was reheard en banc. The court was all too happy to reaffirm the district court's opinion in part. However, unlike the district court, it made an explicit statement that has gun owners very upset. The Fourth Circuit en banc declared that, contrary to the now vacated decision of our prior panel, the banned assault weapons and large-capacity magazines are not protected by the Second Amendment. That is, we are convinced that the banned assault weapons and large-capacity magazines are among those arms that are like M16 rifles, weapons that are most useful in military service, which the Heller Court singled out as being beyond the Second Amendment's reach. Put simply, we have no power to extend the Second Amendment protection to the weapons of war that the Heller decision explicitly excluded from such coverage. It further stated that the appropriate level of scrutiny to apply to such a challenge was intermediate scrutiny. In other words, the court believes that the Second Amendment does not warrant the highest level of protection when analyzing a challenge to the constitutionality of a law it may infringe upon. Many people have been asking me, how will this affect me? Remember at the beginning where I listed the states covered by the Fourth Circuit? This decision is only binding on lower federal courts in those states. Unfortunately, that means if a law restricting a certain type of firearm is passed in any of those states and someone brings a challenge to the constitutionality of it under the Second Amendment, it has now opened the door for restrictions on what firearms the Second Amendment protects. If you reside in a different state, no courts are bound by that decision. However, they can cite to it as persuasive authority, which can be problematic, especially if other courts begin to adopt the perverted logic employed by the Fourth Circuit. When we were reviewing the script for this episode, John asked me how we could fight such a terrible decision. The fact of the matter is, there isn't really any way to do so, short of contacting your congressional representatives. As you probably know, we have a system of government that is designed to have checks and balances on one another. If you didn't already know that, don't worry, I've got you covered with another episode of Schoolhouse Rock in the description. As the judiciary is independent of the legislative branch and not directly elected, there are only two ways this decision will be overturned. The first is if Congress takes some sort of action. The second is if the Supreme Court decides to hear an appeal. When a case is decided by a court of appeals, either party can petition the Supreme Court to grant a writ of certiorari to hear the case. The Supreme Court's under no obligation to hear any of those cases. In fact, the court receives about 7,000 requests a year to hear a case and only grants certiorari to about 100 to 150 of them. Time will tell if this is one of those cases. Hopefully that gives you a better understanding of the recent decision from the Fourth Circuit. If you guys like this episode, you know what to do. Hit that like button and share it around with your friends. If you have a question you want answered on the show, head on over to the legal brief section on theguncollective.com. Be sure to check out my website, adamkraut.com, for more information on my quest to serve you on the NRA Board of Directors. And don't forget to like the Gun Collective on Facebook, Instagram, YouTube, Full30, Snapchat, and wherever else you can catch us on social media. And as always, thanks for watching.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.